All right, we are joined today by Andrew Hayes, who I think has been on twice before, once to discuss how the United States treats paupers or poor people who are trying to immigrate, and we did a comparison of US and Canadian law, and the other was about um, I think the title was Judges Virtue Signaling, but generally just restrictions on the behavior, I guess, of people in power. And in that episode, we discussed a judge who had worn a Trump hat in court, I think, in Toronto. I'll link to both episodes in the show notes. Today, we are here. Andrew is joining to provide us with basically information and the US perspective on something that has been raised a few times on this show and ever increasingly in US immigration law, which is people who are being found inadmissible to Canada for misrepresentation and banned for 5 years because they did not disclose visa refusals or denial of entry to the United States. And there's all sorts of weird questions about what is actually a US visa refusal and what does this term mean? Is this a refusal? Andrews is a US immigration lawyer who practices US immigration law in Vancouver. Thanks for coming back on.
Thanks for having me, Stephen.
Yeah. I don't know which scenario we want to start with. I think actually we should start with the latest trend and the one that I have found most perplexing, which is administrative processing in the United States, which is a term that I had not heard of 2 months ago, but now seems to be a topic of discussion every week. What is administrative processing?
Administrative processing, or AP, is a term used by the US consulates when a visa is not able to be issued after an interview and further processing is required. So the context is important because not every nationality is required to get a visa. And we can talk a little bit about the special exceptions for Canadians, as well as the visa waiver program for certain countries that are part of that. But the general rule is that a non-immigrant, a person that is not a US citizen who wishes to travel to the United States for a temporary purpose, is required to get a visa sticker, stamp, from a US consulate abroad. In order to have that stamp be issued, a consular officer, part of the Department of State, has to interview that individual. There are only two outcomes to an interview. Either the visa is issued or the visa is refused. And I think the terminology here is what's quite interesting, especially for your purposes. So when a visa is refused, there are two subsets within that. One is it's denied in the sense that the issue is over. There's no review. It's not going to be issued, or it's undergoing administrative processing. So when a visa is not issued, the relevant code section is INA 221G, which basically says that the officer is not going to issue the visa. Admin processing we kind of call it a black box because you don't really know what's going on behind the scenes there. And if anyone out there has had one of these, it's quite frustrating because you kind of email the consulate and they say, we're doing what we've got to do. We'll get back to you. Functionally, what can be happening here is a great number of things, including security opinions. For example, let's say there's a database hit, a class database hit about someone's name or perhaps someone that's linked to them, and that needs to get sorted out in the background. Admin processing can go on for a year, sometimes even multiple years. And so frequently what happens is that an applicant will be told, hey, we have to do more processing, take your passport back, we will let you know. They don't think that they have been denied because they've been told, hey, we're still processing, admin processing. But functionally, they have been denied for the moment. Now, when that processing is complete, again, we have the two options. It remains refused or it is approved. So somewhat ironically, you can have a visa issued and still be refused.
And it seems so. Do they get a letter stating that they're subject to administrative process? Is there a procedural fairness letter?
Usually a letter, a 221G letter is issued. And the concept of procedural fairness, consulates try to be fair because, in my experience, consular officers are some of the most professional folks out there. They are highly vetted. They're very competent. They're trying to do a good job, but they're not really required to do very much because when you're talking about the zenith of of executive power outside the states, kind of whatever process you get is what you're due. So it's very hard, for example, to have standing to sue the Department of State in a visa issuance scenario. So yes, they try to be fair, but what they give you is what you get.
Yeah.
So first of all, and this is a bit of a digression, but ultimately what you're saying is that in terms of a regular visa application for somebody who is not subject to a visa waiver, every person does have an actual interview with the visa officer before a decision is made on their application.
That is correct. There is an interview waiver potentiality. That is an option that the officers can use, but the default is there is to be an interview, and that interview waiver provision is limited, usually to people who have already been issued that visa before.
Okay, so the interview waiver would be available in the event that it was essentially going to be approved, not if it was going to be denied. Is that right?
That would be my opinion, yes.
Yeah, okay. So, I mean, when we're talking about procedural fairness, it's sort of the default is going to be that the interview is going to take place.
It's
Yes.
very different from Canada.
Yeah, extremely different. It's just funny because in Canada, the default is that there's not going to be an interview. And so, and again, they always talk about capacity and numbers and volumes and all of that sort of thing. And so
But the United States was able to figure it out.
yeah, exactly. So that's really where I was going, Steve. So thanks for taking me there.
It's interesting you bring this up. One example of, I guess, possibly a negative outcome of having to do an interview is that right now, getting a visitor visa, right, B1, B2 appointment in Canada to the United States is a multi-year backlog. So if you are, let's say, a permanent resident of Canada, permanent residents of Canada are no longer able to travel to the United States without a visa. I can talk a little bit about that. That was not always the case. You're going to be waiting years, multiple years.
Has that always been the case, or was there a recent spike because of changes at the port of entry regarding flagpoling?
Well, that's a good point. Maybe there are more applicants overall. That could well be one of the causations here. But really, what it comes down to is honestly backlogs from COVID. And it sounds ridiculous that we're still talking about COVID, but the Department of State more or less shut down visa interviews for 6 to 8 months worldwide. They were still operational, still doing some emergency appointments, but I mean, really, their entire caseload stopped or case processing stopped. And this really caused a lot of disruption. Having our American Immigration Lawyers Association does do liaison meetings with the Department of State, and they've been very frank that this is a major issue. They're very focused on it, and it's just a capacity issue. It's a lot of in, and they can only get through so many per day, and they're working on it.
Yeah, my 11-month-old is in the queue for a Nexus appointment, and the way the bookings are done, I think they're waiting for her to be able to talk before the interview will be scheduled. But going back to administrative, or were you going to say about Nexus?
Oh, that's a whole different issue, and that was a dispute over I believe over firearms. Who gets to carry firearms?
The Americans want to be armed here. I don't do a lot of Nexus work, but I know a few of the senior officers because of the work that I do, and it's it's also a great card. Everyone should be applying for it. Anyway, going back to administrative processing, I can actually hear a lot of Nexus card holders saying, no, don't tell anyone else to apply. But so, I mean, the big thing to note is that, and I think you've been contacted by other lawyers to get opinions on this, is that the US shares refusals with Canada And this administrative processing seems to be showing up as a refusal to the Canadian authorities, who are then sending letters to applicants saying, why did you not disclose this refusal? And the applicants are saying, I don't know what you're talking about.
That's exactly it. So what of course, I don't know exactly how IRCC defines misrepresentation, but my arguments have been that it's an applicant who has received 221G, which is a refusal. That is, I would say, legally a refusal.
But they don't get a letter which says that, right?
They usually do, but not always. So sometimes I'm thinking of one example where the person was basically told, "Hey, we're working on it." So they really, in my opinion, did not believe that they had been refused. It's really, whether or not that person understands that they've been refused or not. So one can't generally misrepresent something if they, in good faith, believe that they have not been refused. And in fact, the Department of State has actually put up a new page on the web there, kind of explaining a little bit more about this. And I've actually cited to this to say people are genuinely confused about this because it is confusing.
But it seems like they're not saying like your application is refused. They're saying we can't approve it now, but we're doing more processing. Like it reads like if IRCC were to treat every procedural fairness letter as we are refusing your application now, but please provide us more information. Like it's not a final refusal.
Correct. It's not a final refusal. It is a refusal. It is a temporary refusal. And so I guess the irony is that you can be refused, and then let's just say your name, somehow is associated in one of these massive chains of databases, and they say, "Oh yeah, it's not actually you. No problem. Here's your visa." That person's been granted a visa, but they've also been refused.
It sounds a little like what happens when somebody loses their status in Canada, but then applies for restoration and then is restored. It's like, yes, you lost status, but then you regain status. Again, it's still a loss of status, but and again, there's clearly a loss of status, but maybe that is even more clearly a loss of
Yeah, I feel like that's
status.
more clear than
It
this.
is more clear. This is like really, but I think that Andrew's quite right, that you do need to go back to what the definition is of misrepresentation and even the innocent mistake defense, because what Andrew's describing, the what you understand in good faith is kind of what the innocent mistake defense is. But I think the challenge we have is how varied the application of that defense has been in the jurisprudence, and that you're not always before a judge even when you make that when you plead that defense. And so at the visa office or the immigration processing level, the outcome can be quite varied. So it's materiality and then innocent defense. I get stuck on materiality, and I think I've discussed that before. So perhaps we should sort of digress and talk about what the misrepresentation issue is, and then sort of, I don't know.
Well, I mean, the in a sentence, is it misrepresentation to say that you've never been refused a visa if you had administrative processing in the United States? I don't think that it is. And I'm hoping in this episode that greater awareness is brought both to the public, lawyers, consultants, and the department regarding what administrative processing is, and that it is not a refusal in any sense of how we view it in Canadian immigration law.
I don't know. Do you think so, Andrew? Because I think that what you're suggesting is actually the opposite, but perhaps I'm mishearing.
Well, I would argue that it is a refusal. It can be one of two types of refusals. It can be essentially a final refusal or a temporary refusal. And I think that can be very confusing to a non-expert. I mean, just imagine a person goes in and they say, "Oh, hold on, we got to do some more processing." And maybe they give them the 221G letter, which some people do, and it does say the word refused on that letter. Some people do not get that letter. Again, in fact, the situations vary. I would say most reasonable people think, "Oh, hey, they can't give it to me today, but they're still working on it." That is true. is it then a misrepresentation to say that I was refused a visa, especially if, let's say, that visa was then granted? I think most people would say, hey, you granted the benefit that I requested. How could you possibly say this was refused?
Mm.
So it's really about interpretation.
Yeah,
I
agreed.
can provide the link to Department of State's explanation of administrative processing, in which this issue is kind of fleshed out from their perspective. And I don't know if that's something that can be shared with the show notes. It would be helpful for
Yeah,
other
for sure.
Canadian practitioners.
Yeah, you could perhaps even share a screen on that, Steve, because I think that's the one that you actually provided to me as well. But I mean, from my perspective, as a Canadian practitioner, what I would say is best practice would be, if you know about this in advance, you certainly disclose it in advance and say, for the out of an abundance of caution, I'm going to say that there was this 221G decision made, and then ultimately it was either refused or approved in the end of the day, or else we don't know what the final outcome was, just to like put that forward. And then you make submissions on it and say, like, this shouldn't impact the decision on this Canadian application for whatever reason. Or if you're getting a PFL from Canada saying, how come you didn't disclose it? I think you can say, I didn't disclose it because I did not believe it was a refusal. I do not believe that the misrepresentation is material, in the sense that, that it could not have caused an error in the administration of the act, and you make your submissions on that because it's not reasonably foreclosing an avenue of investigation. Or in the alternative, that it was an innocent mistake. And in this respect, innocent mistake was because it's not actually a final decision. And going to what Andrew has said is that it's actually more akin to a PFL in our system, like saying that a further investigation is still required, as
Yeah,
opposed to
it would
being a
be
final
like if
decision.
every time an applicant sent a request, hey, please process my application now, and IRCC sends back the letter saying, no, we're still processing it, that was a refusal to issue a visa, right? Like, it's reading
Yes.
refusal, in my opinion, so broadly. And I understand here the United States technically calls it a refusal, but where that letter is even sent, but it's not, I just don't think it's a refusal in the Canadian sense.
Yeah.
Why do they sometimes get the letter and sometimes not?
Just comes down to comes down to the circumstance. There are a lot of consulates around the world. I would say that the procedure is generally to give that letter. In my experience, I ask clients if they have that. Maybe sometimes they don't have. They just forgot that they were given the letter. In my experience, some have it, some don't. As I said, the consulate essentially can do what it wants to do, because it's essentially impossible for a foreign national to sue the Department of State. They just do not have standing to do so. The concept is known as consular non-reviewability. And in essence, it says, okay, when the executive branch acts in the foreign affairs function, it's at a zenith. It's essentially the judiciary is not able to review, quote, a political decision. So it's not really a political decision in the classic sense, but it is at the zenith of its power. So to actually have jurisdiction to sue the Department of State on its administrative decisions, there generally has to be a U.S. party involved. And even then, it's very difficult. And so a good example of that might be a U.S. citizen petitioning for their foreign national spouse. Well, now there are some cracks in the doctrine of consular non-reviewability. This is a very interesting area, and the U.S. practitioners that are kind of exploring this, good luck to you. It's having no reviewability is a challenge.
Yeah.
The
I
world of
mean,
law.
we had an episode with Simon Wallace about the history of deportation, and he did this deep dive on when Canada had to decide whether deportation law would be royal prerogative, subject to judicial review, or just part of the administrative state, and how that decision, 100+ years ago, how different our practices and the state of the law would look today.
Mm. But I'm fascinated by this idea that even the decisions rendered by visa offices are not they're not subject to judicial review or oversight by the courts at all.
Yeah, it's not absolute, and there are, as I said, sort of some cracks in the doctrine of consular non-reviewability.
Mhm.
But the way it's been is essentially that no, the process that you get is the process that you're due, with some exceptions. Uh, I can also note I was looking to this in another matter. The consulates are actually trying to produce. I should say Department of State really here. Consulates are the units through which Department of State does its consular function. So Department of State is actually trying to produce more explanations for denials, because there was a question of, hey, you should at least say what you did here. We're not going to really review your logic, but there is some procedural fairness in the sense you have to actually say what the denial was based on. Now, this is another area which I just have to bring up because I feel like I always do, but it's a part of my practice. The consulate can also deny because deny a visa because it makes a determination of inadmissibility, or it can rest it on the presumption of inadmissibility under 214B. So if the consulate, for example, doesn't want to render an opinion on whether or not there's a reason to believe that a person is a trafficker, for example, they can just say, oh, well, 214B, we're just not satisfied, you're entitled. 214B is very difficult to solve
That's interesting.
because the applicant has the burden of proof to satisfy the officer that they are entitled to the non-immigrant classification that they're requesting. So, not satisfied. Case closed. I'm not even going to talk
Wow.
about what we may think we know about your connections or whatever. Or they can go the other way and just say, yep, we think that we have reason to believe that you're a trafficker or a terrorist or connected with organized crime. These are all the reason to believe categories, which are always very tricky, because what is the reason? Well, it's very hard to find out. Sometimes it's completely spurious, right? Somebody's name is in a database, or maybe there's some sort of actual connection out there. But as the individual, very difficult to find out what that is.
This is actually very informative because it does actually provide some kind of insight as to why Canada is so interested in finding out that there are previous US refusals, because what might be built into that is of interest.
Oh yeah, I mean, why someone would be denied entry to the US. I can see where there would be materiality there. I want to go on
Mhm.
to scenario 2 of what is this in the US context,
Mm.
which is people who are in esta and are told by operation of law that they are no longer eligible to participate in esta. So an example that Andrew, you recently helped with was dual nationals of Iran who all of them received notification in 2015 under the Obama administration that they were no longer eligible to participate in esta. And we were contacted by someone who had a procedural fairness letter from IRCC that the fact that they did not disclose this meant that they had not been disclosed that they had been refused admission to the United States, even though they weren't in the United States and had not actually tried to enter. IRCC took the position that a declaration that someone was no longer eligible to participate in esta meant that they had been refused admission to the United States. So how does that all work, and how is that recorded in US databases?
Maybe it would be helpful if I just quickly review the structure in which ESTA, Visa
Yeah, I
Waiver,
couldn't
waiver
even remember
Program,
what it stood for. I was trying to think, what does ESTA
Yeah.
stand for? So yeah,
Electronic System for Travel Authorization.
okay. It's what our
So,
ETA is based on.
Mm-hmm.
so just very, very quickly. So it's the default position from the US's perspective is that everybody requires a visa issued by the Department of State through its consulates in order to seek admission at the border. So getting a visa does not mean you are admitted to the United States. It is a prerequisite. Customs and Border Protection, the officers that control admission, part of the Department of Homeland Security, are required to see a valid visa and a valid passport, usually 6 months with a 6-month expiry, in order to consider admitting that person to the United States. It's a prerequisite. Now, there are exceptions to this. So the first major exception are what we call the visa waiver countries. So the program is the visa waiver program. That, I believe, is 41 countries, much of Europe, countries in Asia, Japan, it's Singapore, I believe, is in there as well. So those countries generally have a good relationship. And what I mean by that is an informational relationship, meaning that the documents that they are presenting are probably authentic, means that the United States has some sort of information sharing reciprocity with those countries so that they can say, okay, we can see that these individuals are probably low risk. So it's basically a low risk analysis. So, okay, rather than going to consulate, we will allow you to waive the visa requirement, hence the name of the program, Visa Waiver Program. ESTA is the vehicle through which that is performed. So that is the actual portal that individuals type their information into. ESTA is, I believe it's almost entirely automated. There may be some human factor there as well, but my understanding is that it's essentially automated. And then it kicks out an ESTA authorization. That is essentially in replacing the requirement for a visa. So if you have this authorization, you are not required to have the visa, and then Customs and Border Protection can admit an individual under two statuses. So this is the key part too. ESTA doesn't cover everything. It covers visitor for pleasure, visitor for business. So WT, WB. The analogy there would be B1, B2. That's the non-immigrant category. There are restrictions on this, right? It's not a 6-month entry. It's a 90-day entry. There are a number of other restrictions as well. So, and then finally, I just have to mention Canada. Canada is very, very special. Canada is visa exempt. So you're just not exempt. Canadians just don't require the visa sticker for almost all categories. Certain categories they still do. For example, investment-based ease and some other aspects as well, like K. So what happened specifically with regard to individuals who are nationals of Iran and also potentially a visa waiver country. So I don't know, I'm just going to throw out a random visa waiver country, Germany. So if you were born in Iran and you are a citizen of Germany and you are not using your Iranian nationality for visa waiver, there is certainly no visa waiver program for Iran, but there is for Germany. So you're a dual national in a sense from their perspective. What happened was the certain countries are considered to be more risky, I guess you could say. Iraq is one, but the program, the CFR, the Code of Federal Regulations, actually opens up an area that says other countries can be kind of put under this area. There was a determination that, hey, if you're a dual national of a visa waiver country and Iran, you're ineligible for the program. So in essence, you did nothing, right? None of us control where we were born. That's just a fact of life. So those individuals were just essentially ineligible to apply for visa waiver anymore. So basically, you weren't denied visa waiver; you were ineligible for it. I guess
So,
go ahead.
Yeah. So what like would the U.S. record that? Like, does the U.S. treat that as a refusal or a denial of admission?
Absolutely not. And so to me, those individuals that were caught up in that particular ineligibility are truly the most blameless of all, because it was really just, hey, sorry, you were born in this other country, you're no longer eligible. But let's say another individual, let's say they had, I don't know, there's some sort of immigration violation. We'll say that that's the basis, and they are no longer allowed to participate in the program because of their actions. They are still not denied anything. They are not denied a visa. They are not denied admission. They are simply no longer in the program, the visa waiver program. Why is it not a visa denial? Because if a person is out of visa waiver program, they're still eligible to apply for a visa. In fact, the public ESTA documents make that extremely clear. They say, yes, okay, you're out of the program. It doesn't mean you're inadmissible. It means that you're no longer part of this program. Go to a consulate, see if they issue a visa or not. And many people are. Once you have a visa, you can then seek admission. So to say that a visa refusal is akin to a denial of admission is fundamentally incorrect, because the visa is a prerequisite to seeking admission.
Do we know how it's required? Like, I'm really curious in that case why Canadian immigration officials thought that this constituted a denial of admission. Like, obviously the letter doesn't say, but they did.
Unfortunately, I don't know the answer to exactly how that data is shared, but I can say that generally speaking, Canada and the United States share an awful lot of information. And I'm sure you've seen this in this is one example in your practice. In my practice, CBP, Customs and Border Protection, know an awful lot about people's criminal history, like way more than you'd expect, including youth issues that theoretically should not be publicly available, as well as many other things. So information sharing is large between the two countries. So wouldn't be surprised if this is just shared wholesale and then misinterpreted on the Canadian side.
Or perhaps even information about investigations that did not lead to charges, and then kind of general global information about policies like the removal of this option to apply through the visa waiver program was then used to try and block admission, even though it's not actually a denial of any sort.
Yeah. I mean, and after that one client got the procedural fairness letter about this, I wrote to IRCC to ask about the Mexicans who all had their visas canceled or ETAs canceled by operation of law, because I started to think, well, what's the difference? IRCC wrote back to say, quote, as per the question that appears on the ETA or visitor visa applications, it is explicitly asked whether the foreign national has ever been refused a visa or permit, denied entry to, or ordered to leave Canada or any other country. As such, a Mexican national who had an ETA canceled during the imposition of a visa requirements does not need to disclose this, as it was an administrative action taken due to regulatory changes which made them no longer eligible to hold an ETA, but their application was not refused. End quote. So, I mean, we know through the jurisprudence that terms are getting read into that question by officers more broadly than this email from IRCC suggests, although hopefully this email I tweeted it and posted it to LinkedIn to try to push back on some of the jurisprudence to say, hey, I know that officers are judicially reviewed on the reasonableness standard and IRCC guidance isn't binding, but here's, at least an official IRCC position. But yeah, I don't see what the difference would be between people who are declared ineligible to participate in esta and what happened with the Mexicans.
And this is also, I mean, I know I've talked to you about this decision, Steve. I don't think I've talked about it on the podcast, but the one from my practice where my client was found inadmissible for misrepresentation for failure to disclose an ETA refusal. And this was something that I argued before the board. And again, it's the same to me for an esta refusal, because the question is, have you ever been denied a visa? And for me, and this was the argument that I made before the board, that this is not a visa refusal. It's a refusal of a visa waiver. And so I understand that that the question asked on the application is whether or not you've ever been denied a visa. But again, in terms of what you're asking about, the comment that you're making about words being read in, the issue that came up at the board was whether or not this was a material misrepresentation. In the case that I argued, the facts were completely disclosed. The fact that a work permit had been denied was disclosed, but the fact that a subsequent ETA was refused on precisely the same facts was alleged to be a misrepresentation. And in the case, we ended up succeeding on humanitarian and compassionate grounds. And so there was no interest by my clients to appeal or to JR that decision, because the outcome was the one that we sought. But again, in terms of this whole notion of reading in, so if you're asking whether or not a visa or an ETA or an esta refusal has been rendered. I think to me there's a distinction. This sort of goes to the point overall about administrative review. Is that a refusal? But is an esta or an ETA refusal actually, is that a question that's actually being asked? And so
Well,
to
I
me,
just come back to like what I said last podcast. The solution to this is just change the forms. Like if they want
yeah,
to
if they
include
want
this
to
stuff.
ask that,
Before
then
I get to the last scenario, Andrew, does the US have the same concern about like whether like the same broad interpretation of misrep? Are Canadian, do you get quite like, does the US say, hey, you didn't disclose a Canadian allowed to leave, which is the same as a
great
refusal,
question.
or does this same issue arise in the United States?
Not exactly. There are, so for example, in the context of a visa application, there's a specific form known as DS-160 and DS-260 for immigrants, non-immigrant being DS-160, in which many questions are asked. And some of those questions are a little vague. And so I would say that there is an analogy there, but not to the same degree that you're talking about. Now, a visa is a visa, in my opinion, right? So only one agency can issue a visa. CBP can't issue a visa. They control admission. Department of State is the only possible agency that can issue a visa, and they do that in the consular context.
Yeah.
To say that ESTA is the same thing as a visa is just fundamentally incorrect. And I
Right.
get it. People say, "Oh, I hear Canadians do it all the time. I was working on a TN visa." No, you weren't. You never got a consular issued TN visa. You received status under USMCA. Yes, I understand it's a term that is used broadly, but I would argue that on a government form, when you use the word visa, it's got to mean the term of art, visa.
Thank
But
you.
and so do the
That's big.
forms ask, have you ever been refused a visa to any other country?
Not other countries, no.
Oh, well, then yeah, this issue wouldn't arise.
Yeah, I know. But this preoccupation with misrepresentation, it's not the big workhorse that it is here in Canada.
The U.S. is primarily interested in whether you've been refused something, admission or visa or something related to that to the United States.
Interesting.
And also, I know this is a little off topic, and we've got to move on to number 3 here. But one of the big questions that's asked is whether a person has ever committed an offense that they have not been arrested for. So that's a real fun one to try to
Oh,
advise your
that's
client.
We
yeah.
got that too. Yeah.
Wow. That
Oh, that's like, yeah, yeah. I think that's a whole episode right there.
Could
Yeah.
well be.
that's
I would love to see
government makes
the,
everything a crime so that
yeah.
they can
I-
get anyone.
But I would
When
love
is a
to do a
crime a crime?
comparative conversation about like how that's actually dealt with in the
Yeah. Scenario 3. If actually the broader one, if somebody shows up at the Canada-US border on the American side and says that they aren't seeking admission to the United States, they're just showing up there to Flagpole, which is the process under Canadian law, which if you want to apply for a work permit at the port of entry, you have to go down to the United States, turn around and come back. The colloquial term is flagpoling. Chuck Schumer actually was recently complaining about it in the news because I think the US border officers don't like it when, hundreds, if not thousands of people are showing up at the border saying that they don't actually want to go to the United States. They just want a flagpole. How is that administered on the US side?
Well, that's a good question. I will say as much as I know about the topic. So I can at least I can sympathize with Customs and Border Protection officers when this situation appears in front of them. So generally speaking, law enforcement and the judiciary in the United States operates on controversy. For example, a legal question cannot just be submitted mostly to the courts for a hypothetical answer. And that's why almost all jurisprudence is based on an actual controversy, right? Brown versus Board, all the famous cases involve real people in real controversy. Same thing at the border. You can't go down to the border and say, hey, officer so-and-so, I'm going to give you a hypothetical. What would you do under that? They're going to say, don't ask me. If you want to find out how I'm going to determine this, put yourself into controversy. So when a person comes down and says, "Hey, officer so and so, I'm not here to, I'm not here for admission. I'm just here." It puts them in a difficult spot because officers are there to adjudicate admissions. So I think that there isn't really an established concept in the law to deal with flagpoles. Now, there's enormous discretion at the border. Officers can do an awful lot. So I wish I could speak a little bit more as to what CBP actually thinks about flagpoling. I cannot, but I'm glad to look into it a little bit more. But I think generally what they do is just say, all right, we'll mark you in, but we're not going to put this essentially under an adjudication.
Yeah, and I've never seen this issue arise. I've always just been curious. Like I've never seen flagpoling showing up in PFLs as you didn't disclose a flagpole attempt.
I think that might be a West Coast phenomenon, though. From what I understand, it can be very, like with everything, it's very port of entry specific.
Yeah. But it's not like there's no federal court jurisprudence about a misrep allegation around this.
True enough.
And like sometimes, yeah, it's never been clear how exactly is it being recorded by the Americans.
Experientially, it doesn't look like they're making official determinations because I haven't really seen it either. But if they chose to, I mean, they can do a number of things, right? Often the default position, like the consulates, is 214B, right? Which is, oh, you haven't, you haven't shown me you're entitled to admission under the classification you're requesting. So what you'll see is when that's documented, it says 7A, which is 212A 7A11. Intending immigrant without the right documents. It's the default provision that's in place there. So I don't think that they're doing that for flagpollers. I might be mistaken. There might be examples of when they're doing it, but that actually would be a refusal of admission, right? Because you failed to overcome the presumption of immigrant intent. Yeah, so I don't think that they're doing that, but I wish I could shine some more light on this.
And I mean that process could change anytime in the future. CBSA is constantly changing its processes around this.
Yeah, but I guess the question really is, like, from your perspective, how would you react to the idea that somebody is going to venture toward the border with with this kind of a request? Does it fill you with concern or like?
Well, I suppose. As a U.S. lawyer, not really, because 7As aren't a big deal really for individuals. Yes, it has to be disclosed. 7A refusals have to be disclosed, but it's sort of default provision. What I think on the Canadian side, it's a little bit more significant for the reasons that you guys have mentioned here. But I would like to know exactly what their internal policy is in this, because they have to, when an individual comes to them, they have to deal with them, right? They have to be processed in some way. People are not generally just allowed to wander around the ports of entry without some sort of engagement from the CBP. So,
yeah, interesting. My last question. Well, two questions. Second last question, and it's one that I've talked about. I think maybe not on the podcast, but just before in terms of how hard interpreting some of this is. Let's say, and I'm not saying this happened, but let's say that I was driving in a car from the Canada to the United States near Glacier National Park, and I drove up to the US border, and the guy says, "Do you have any wood in your car?" And I say, "Yeah, I bought firewood over there." And he says, "Can't let you in right now. You have to walk out of your car, dump all that wood in that bin that says Canadian wood, back to the car, and then I'm admitted." Was I denied admission to the United States because I had wood in the car?
Comes down to whether or not they marked it in their system. So if they marked it as a 7A, then yes. If they decided to just say, yeah, whatever, come back, then no.
Yeah.
And
it's to me, it's just an example of like how hard it is to know how to answer these questions. Same with that. Have you ever committed an offense? Like, it's so broad.
How much this is just a tag on question is like, how much, like, how much information is actually contained in the reasons for decision, and how much of this information can you obtain?
From Customs and Border Protection?
Mhm.
A decent amount. So if one really wanted to get to the bottom of it, I would suggest doing a Freedom of Information Act request. I know that there are equivalents in Canada, to see if there's any record. The FOIA has never contained the full record, of course, but they often will show if there's been official determinations, especially if there has been a person goes to secondary inspection and the officers make a determination and provide a transcript. That is very, very helpful to get from FOIAs to see what has happened. My guess is the firewood example. My guess is they probably just wouldn't log it in and just say, we didn't come to a determination. I should also mention there is a concept of withdrawal, whether a person can withdraw their application for admission, and whether that itself counts as a refusal or not. So if a person is allowed to withdraw, or the border constructively does that for them, is that itself a denial?
I can tell you the Canadian position, because we did a case on this and it was just adjudicated, is that it's called, the Canadian court said it was an involuntary withdrawal. So it was refused admission. At least that was how an IRCC officer treated it, and the judge said it was reasonable to interpret it as involuntarily withdrawn.
But then that is a refusal.
I generally treat them the same way. The firewood example is a really good one.
Yeah.
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 And then the other question, in 1 minute or less, who's going to win the US election and why?
Oh, it's going to be interesting.
No pressure. Yeah.
You actually want me to answer this question?
No, it's up to you. I don't know. It's I've given up trying to predict.
I have no idea. I will say that if former President Trump is reelected, it's going to be very, very interesting for the U.S. immigration world. The last go round, there was a lot of interest in looking at the agencies and kind of, in my opinion, kind of demoralizing some of the agencies, specifically with the furloughs at USCIS. So it will be interesting to see how much more effective the attack on the administrative state will be in a second.
Oh yeah, they got rid of deference, the Supreme Court recently. How does that impact immigration law?
That's definitely a whole podcast in itself. Chevron deference is very important for all all administrative law and immigration in particular. I think it's going to be many years before the full effect is felt. I don't know this personally, but I would imagine there are a lot of appeals lawyers out there very excited about challenging decisions that were based on agency deference, specifically Chevron. It's going to change a lot of things, but it's not going to be immediate.
Yeah, I think the big thing coming up from a Canadian side is that the CUSMA renegotiations are supposed to start 2025, 2026. The government's doing consultations on it now. And without saying too much more, those negotiations would probably be very different under a Trump administration versus a Biden.
Oh my goodness. Yeah, yeah. Oh my goodness. Yeah. CUSMA being, for some who still consider that NAFTA, but
of course,
and USMCA in the United States,
yeah,
and MUSCA in Mexico, because every country has to name it differently so that they're first.
Just to be completely, yeah.
Yeah, that's a good note to end on. It just shows kind of the silliness of it all.
The silliness. Yeah.
And I've had that where like I'll be talking, when I went to AILA this year, it was like, oh, CUSMA, and an American would be like, you mean USMCA? And it's
yeah,
yes.
Yes, let's agree to disagree.